Good morning, everyone. My name is Mark Breslauer, and I'm the CEO at the United Way Greater Victoria. Welcome, and thank you for attending our Estate Planning 101 session. I'm sure you'll find it very beneficial. I'd like to start by acknowledging and thanking the Lekwungen-speaking peoples, including the Songhees and the Esquimalt First Nations, upon whose land we live, work, and play. I think it's fair to say that when COVID-19 hit, it took us not only by surprise, but by storm. There's been a toll on our mental health, our relationships, and our financial security. These unprecedented times have caused many of us to consider our plans for the future and what legacies we might leave behind. In light of this, we thought it timely to present today's session. I'm sure all of us want to ensure that our families are looked after and that the community here on the island is sustained in as strong and healthy a manner as possible. So we have some very insightful speakers to help us in that regard today. And it's my great pleasure to first introduce Babby Tathgar and Maria Raymond from McConnon Beyond O'Connor and Peterson. And I think you'll really enjoy that portion. In addition, we have some financial planning and management expertise by way of CIBC Wood Gundy. And both Neil Chappell and Graham Eisenegger are here to join us. A big thank you to all of our fellow panelists and to those at McConnon Beyond O'Connor and Peterson and CIBC who aren't with us on this call, but who generously support the United Way and our community. United Way Greater Victoria was here long before COVID-19 impacted our lives as it is doing. And we will be part of the rebuilding, recovery, and rally to unite local people for local good. So I thank you all for attending today and demonstrating your local love. With that, it's my pleasure to turn the mic over to your host for today, Daryl Ells. Daryl is our Donor Relations Officer here at United Way Greater Victoria. Thanks again and enjoy today's session.
Thanks very much, Mark, and welcome everyone. I'm Daryl Ells, the Individual and Plan Giving Officer here at United Way. I hope you all received your will planning guide and our legacy giving brochure. I sent those out yesterday. If for any reason you didn't receive them, please get in touch with me directly. My email address will be up at the end of the session, and they are available for download on our website. So a very useful tool. We have a wonderful lineup of speakers today, and before I formally introduce them, I wanted to share with you a few things about United Way's Legacy Giving program. We're just going to wait for this screen share to come up. Thanks very much. At United Way, we support our local community by investing in the social sector to address immediate needs as they emerge, and importantly, to work to solve complex social issues. So this is to say we take a long-term view of our impact in the community and where and how we locally invest donor dollars. So as an illustration of this are our three new areas of action: isolated seniors, families in need, mental health and addictions. And these areas will guide United Way's path forward in the foreseeable future. Our community impact approach is very much geared to achieving lasting, measurable improvements in the well-being of individuals, families, and community. So through our legacy program, we invite donors to continue their impact well into the future and to create lasting, meaningful change by helping future generations in Victoria. A legacy gift is a long-term investment in the community, one that is committed and celebrated now, but only takes place much later on and takes effect in the future. So like all aspects of estate planning, these types of gifts take considerable foresight, and examples are bequests, life insurance, gifts of assets, real estate, for example, gifts of securities. And our panelists today will go further into these issues. So these types of gifts have very little, if any, immediate effects on your finances. And most importantly, And I think this is one of the key things about legacy giving. It's available to anyone, at any giving level. For me, that's one of the most wonderful things about offering a legacy gift. To the next slide, please. So if you are considering a legacy gift in your estate plan, it is another fantastic way to offer support to United Way. It offers great potential tax benefits. And importantly, donors who inform us of their plans are considered members of our Legacy Circle. You can become a member of our Legacy Circle program. To the next slide, please. So through this program, we offer personalized opportunities for involvement, such as invitations to events, public or private recognition, and comprehensive annual reporting on our activities. Your legacy gift can assure United Way can continue to sustainably invest in our programs and community partners well into the future. It's a wonderful way to keep making an impact out in the community, and importantly, it's a great way to inspire others to give. So if you'd like more information about our Legacy Circle program, please be in touch with me after the session, and we can arrange to speak further. So without any further delay, I'd like to introduce our wonderful speakers today. From McConnell Beyond O'Connor and Peterson, we have Maria Raymond. Maria received her law degree from the University of Victoria in 2019. She articled with McConnell Beyond O'Connor and Peterson prior to a call to the bar in 2020, and has experience working in both the litigation and solicitor practice groups. Her preferred areas of practice are business and corporate law, real estate, and wills and estates. Next up, we have Bavi Tathgar. Bavi was born and raised in Victoria, BC. He joined McConnell Beyond O'Connor and Peterson in 2019, and has since worked primarily in the area of real estate law, wills and estates, and business law. Bavi is an active member in his community with his charitable involvement, and he is fluent in Punjabi. Over to our CIBC Wood Gundy Blue Heron Advisory Group, we have Neil Chappell, Vice President, Portfolio Manager and Investment Advisor. Neil graduated from the University of Victoria with a Bachelor of Commerce degree and joined CIBC Wood Gundy in 1996. Neil specializes in building long-term relationships and financial plans for his clients. He focuses on overseeing portfolio design and helping clients meet their financial goals while investing in their values. Alongside Neil is Graham Eisenegger, the Portfolio Manager and Investment Advisor. Graham joined CIBC Wood Gundy in 1998, and for over 20 years has built rewarding long-term relationships with his clients. He's known for his quick wit and insightful observation that aid in financial planning and in his oversight of portfolio design. Graham and Neil founded the Blue Heron Advisory Group in 2013 to provide their clients with a higher and more comprehensive level of service. So we have a number of topics to cover this morning, and we'll get to that in just a second. So from the legal perspective, Bavi and Maria will take us through topics such as the hows and whys of estate planning, covering issues around probate fees, the power of attorney, before Graham and Neil then offer us a financial planning perspective, covering issues such as life insurance and donor advice funds, and etc. So there's quite a bit to get through. If we are going to be collecting questions through the course of the session, if you go to the middle of your screen at the bottom, there's the Q&A function. So please do, if a question comes up for you, please do write it in there. And at the end of the session, we'll have 10 minutes or so to get the appropriate party to address that question for you. So please do make use of that. So with that, I turn it over to Maria and Bavi. Thank you so much for attending, and over to you.
All right, Daryl, thanks for the introduction. So I'm just going to dive right in. So first question is, what's a will and why is it important? Of course, we've all heard the term a will, but it's important to remember that it's a legal document and it outlines your final wishes, allows you to control who manages your estate, and also gives you control as to how your estate will be divided once you pass. So I'm just going to discuss a couple quick terms. The first is executor. That is a legal representative or representatives that are named in your will, who will manage your estate once you pass. The second one is a beneficiary. Now that's the recipient of your estate. It can be a friend, a family, it can be a charity. You can specify at what age the beneficiary will receive their share. And if it's with respect to a charity, you can specify how you wish your legacy to be spent. Now, with respect to other definitions, they're attached in the United Way Will Planning Guide, and I encourage everyone to take a look. So what property can be included under a will? That can be real estate, it can be money, it can be investments, and personal or household belongings. Now, why is it important for a lawyer to draft a will? Keep in mind, a will is a legal document, so you should be getting sound legal advice before you draft a will. Lawyers, unlike notary publics, we can give legal advice. Now, there's a misconception that some believe notary publics are cheaper, and that's just not necessarily true. Also, wills must comply with certain requirements for them to be valid, and that's no matter how simple a will is. And now, if a will is not valid, it can be struck down, or it can also be challenged, and that's something I'll discuss in a few moments. Now, some important questions to consider are, if you have minor children and both parents pass away, who will be the guardian? Do you owe financial obligations to any dependents? And what if your executor passes away? Who's going to be the alternate? Finally, what if your child or beneficiary, what if they're not good at handling finances? Can you appoint a trustee to handle the money? And if so, who will that be? And next slide, please. So when you're picking an executor, you should first give it some thought. It's a decision based on trust, and it's a burdensome role. Currently, I'm an executor with respect to an estate. The sole asset of the estate is a condo. The condo needed to be cleaned and sold, so the proceeds would go to the beneficiary. Now, the condo is relatively small, about 600 square feet. However, there were over 6,000 books and thousands of DVDs and thousands of CDs. And so it's the executor's duty to arrange for the cleanup, to stage the unit, to list it on the open market for sale. Simply cleaning this particular unit took 10 days. I needed, as an executor, I needed to arrange with real estate agents, plumbers, movers, strata companies, etc. So all this took a lot of time, a certain degree of stress, and some obligation. Therefore, you want to be able to pick someone that can handle the additional stress and obligation. With respect to appointing executors, it's important to select more than one, just in case your executor passes away before you. And so when you're naming executors, you can name them in two ways. You can have them in a sequence where the first executor is a primary executor. However, if they pass away, then the second executor, who's an alternate, will be acting. Or you can have the executors all acting jointly. However, it's important to consider practicality. You should be considering, do the executors want to act jointly? Can they even get along? And where do the executors live? It's a matter of practicality. If your intended executor lives out of the province or out of the country, they're likely going to have to make several trips to where you pass to handle your estate. And of course, if you can't pick an executor, just have a frank discussion with your lawyer. Lawyers can be appointed to be executors, but both parties should have a frank conversation to see if it's a right fit and if the arrangement will work. Now, when you're asked to be an executor, consider the role and the duties before you commit, and as previously discussed. So one, do you have the time? And do you even want to act? And you may have to deal with multiple beneficiaries that may not even get along. Now, executors have a fiduciary duty. That means they must act in the best interest of the estate. They have a duty of loyalty, a duty of impartiality, and a duty to account. They must keep proper receipts and documentation for the beneficiaries. And of course, if you don't want to act, you don't have to. You can renounce your position. And some of the responsibilities are safeguarding the estate. You have to change the home insurance, you have to keep the vehicles insured, contact pension companies, honoring funeral wishes, and applying for death benefits. You should be gathering your estate, and by that I mean contacting pensions, bank accounts, investment accounts, and file income taxes. And you also have to pay off the debt. Now, before you distribute the proceeds of the estate to the beneficiaries, you should apply for a clearance certificate, and that's through CRA. This will confirm that an estate has paid its taxes. It lets the legal representative, so the executor, distribute the estate without being personally liable. And then you finally have to divide the estate among the people named in the will to the beneficiaries. So it can certainly be an overwhelming role, and before you commit, I would suggest just talk to a lawyer. And next slide. So what happens if you don't have a will and you pass away? Then the laws of intestacy kick in. So if you pass away intestate, that means you passed away without a will. And your will be distributed according to legislation. And the legislation is the Wills, Estates, and Succession Act. Now the problem here is you won't have any control over your distribution. Your estate will pass in accordance to the legislation, which is WESA. And this will mean extra costs and stress and grief, especially during a difficult time. And the intestacy distribution looks like this. And so if you pass away and you have a spouse and no children, simply your estate passes to your spouse. But if you have a spouse and children, your spouse receives the first $300,000 value of your estate and 1/2 of the balance of the residue. The other half is divided amongst your children. Now, if you don't have a spouse, your estate is divided equally amongst your children. If you have no spouse and no children, then your estate passes to your parents, then your brothers and sisters. So I often hear, where should I keep my will? So obviously keep it in a place where it can't be easily discarded. That's an obvious answer, but the reason is, if a will cannot be found, the presumption is that the will maker destroyed it with the intention of revoking it. However, this presumption can be rebutted by evidence. The con on this would be it would take time and it would cost extra money. Therefore, keep the will in a location where it cannot be destroyed. A safety deposit box, for example, or you can keep it in your lawyer's safe. For example, our law office has over 6,000 wills in a fireproof safe. Now, in regards to preparing your will, who should you tell about the location? I always recommend inform your executor as to the location. So when you pass, they know where to look. Of course, you don't have to actually give them a copy of the will, but you can just let them know where it's kept. So when we prepare wills at our office, we file a wills notice. Now, this is just simply a record that the will was prepared and it's filed with the Vital Statistics Agency. The actual will is not kept there or a copy, but just a record. It has the details such as name, address, date of birth, and the location of your will. Now, with respect to legal disputes, wills can be challenged. Now, if a will doesn't comply with certain requirements, it can be challenged. Typically, a spouse, including a common law, or children have standing to challenge your will. Now, there are certain legal requirements or legal obligations. Now, these are the obligations that the law imposes on a person during their lifetime. And they're found in the Divorce Act, Family Property Act, and the law of constructive trust. You owe a legal obligation to your surviving spouse and children, and your dependent children, during your lifetime. So the law presumes the same in death. In general, there is no legal obligation to make a provision in a will for an independent adult child. That being said, in some cases, there may be a legal obligation towards an independent adult child by reason that the child's contribution towards a will maker's estate. There are also moral obligations, and moral obligations are found in society's reasonable expectations of what a person would do in the circumstances, by reference to contemporary standards and in light of the size of the estate. Now, this is a matter of balancing conflicting claims such as claims of an adult independent child and surviving spouse. Where the size of the estate permits, the will should address the moral obligations towards all the beneficiaries. The court's analysis is if the will maker has provided for the spouse and the children within the range of what's adequate, just, and equitable, the will should not be varied. The court would only intervene to vary a will if what is provided for falls below the range of what's adequate, just, and equitable. In those cases, will can be challenged and potentially varied. Ultimately, this requires a careful analysis of the facts of each case. So what is probate? This simply means a will is reviewed by the Supreme Court to ensure it's valid and it's the last remaining will of the deceased. Once probate is granted, the beneficiaries will have access to the assets. Now, probate fees, they're sometimes incorrectly referred to as death taxes. If your estate is worth less than $25,000, there's no probate fees assessed. If your estate is worth between $25,000 to $50,000, it's roughly 0.6% of your estate. Anything beyond that, probate fees are assessed at 1.4% of your estate. And it doesn't sound like much, but if you have an average home in Victoria, say it's valued at $1 million in clear title, probate fees would be about roughly $14,000. And probate won't be granted until probate fees are paid. Now, there are certain ways to minimize probate fees. One is you can give away your assets during your lifetime, but of course we know that's not always practical. You can designate your assets to have a beneficiary, such as on a life insurance or a RIF. And the third one is joint tenancy. Now, this simply means the rights of survivorship. And I'll use an example of adding a child to the title of a home as a joint tenant, meaning you and your child would own the home equally. So when you pass, your child would automatically get your estate or your home. Now, the benefit of this is when you pass, your child would receive your estate and no probate fees would be assessed. But there's a big risk here. The other joint tenant on the property can register a mortgage or a line of credit to their share of the home. Failure of payment could eventually lead to you paying to prevent foreclosure. And of course, if you couldn't pay that debt, your home could be subject to foreclosure. Of course, you may not think that this can happen to you, but life dynamics can certainly change. Finances and relationships may be stable now, but as mentioned, that can quickly change. For example, if your child owns a business and they encounter financial difficulty unexpectedly, such as during COVID, they could register a mortgage or a line of credit to their specific interest in the property. Or if their interest in the property could be the subject of a family law matter if their relationship or marriage deteriorates. So my recommendation is you should assess your family dynamics, and probate fees can simply be the cost of doing business if you don't want to have any additional charges on your title. There is also the topic of trust, but that's beyond the scope of this presentation. And if anyone has any questions for me, and I'll be happy to answer it. Now, some interesting topics or frequently asked questions are the hotspot clause first. Now, what if you want, for example, if you want equal division amongst your children, but you have given significant loans to one child, what can you do? This is where the hotspot clause will become practical. It'll take into account gifts or loans made to beneficiaries when calculating what they will receive. This can be a debt owing at death, in turn calculated into an advancement by way of hotspot clause. The purpose for this clause is equal division amongst your beneficiaries. Now, the second topic is the codicil. What if you want to make a small change to a will? Do you need a brand new will? The answer is you simply don't. You can just prepare a codicil. A codicil is an amendment to a will. For example, if someone wants to change their executor, instead of going to a lawyer's office and preparing a new will from scratch, you can prepare a codicil. However, I do recommend if you are changing multiple things in your will, including the distribution of your estate, I would suggest to prepare a brand new will. And now, is it safe to prepare a will now? I do understand we're in a global pandemic. However, COVID has allowed for flexibility with respect to signing. I understand some people don't want to come to a lawyer's office to prevent in-person communication. However, COVID has allowed for flexibility with respect to the signing of a will. We can sign wills in counterparts. I will have a copy in my office and I can witness the signatures or a client's signature on Zoom or FaceTime or any other online application. And the last is a funeral wish. You are allowed to put out your funeral wish in a will. However, keep in mind, it's just that, it's just a will. In your lifetime, you should communicate your intentions with respect to your funeral, whether that's being buried or cremated. The reason why it's a wish, the executors may not get to your will until after your funeral. And that sums it up for me. And now I will turn it over to my associate, Maria Raymond, who will talk about estate planning further.
All right, thanks, Bobby. So I'm going to be speaking about powers of attorney and representation agreements, which are advanced planning documents that form another essential part of a complete estate plan. And they can be especially helpful if or when you need some assistance due to illness, injury, or disability. A power of attorney is a document that appoints another person called an attorney to deal with your business and property and to make financial and legal decisions for you. A representation agreement creates a contract between you and your representative, appointing the representative to handle your personal and healthcare decisions if you're unable to make them on your own. I will discuss powers of attorney first. There are various types of powers of attorney. A general power of attorney is effective at once, ends once you become incapable, and is revoked on your death. A limited power of attorney is like a general power of attorney, but for a specific purpose and/or for a limited period of time. An enduring power of attorney is effective immediately and continues into incapability until revocation or death. A springing power of attorney is not active until incapability or other triggering event and ends if you regain capability or on your death. For powers of attorney, the presumption is that the document is revoked once you lose capacity. So in order to create an enduring or springing power of attorney, the agreement must specifically state that the authority of the attorney continues despite the adult's subsequent incapacity. Enduring powers of attorney are the most common now, and they're often used by elderly people in anticipation of losing capacity and often appointing their children as attorneys. The benefit of power of attorneys generally is that they're quite practical. You don't need to be in a bad state of health to have one. For example, if you go on a trip, which is hopefully going to be possible again in the somewhat near future, but you need purchase or sale documents to be signed, or you want someone dealing with your bills while you're away, you could use a limited power of attorney that is only effective while you're away. They're also cost effective. They're much cheaper than a court application called an application for committeeship, which would be necessary if you lost capacity permanently. And it can take quite a bit of time and be expensive. They often cost around $5,000 to $10,000, whereas a power of attorney costs $275 to draft. They're also efficient. Powers of attorney will allow for your finances to be sorted quickly in the event that you lose capacity and are unable to take care of your finances yourself. Major health events rarely give us ample warning to get our affairs in order. They're often quite sudden and shocking, so it's always best to plan ahead. The risk is that it is a document of trust, so you need to be sure that you trust your attorney to make the right decision. Attorneys are guided by legislation and can be held liable if they abuse their power. However, there's no real oversight, so if an issue does arise, the only recourse is through litigation, which again is expensive, time-consuming, and inherently uncertain. Appointing an attorney is a crucial part of the process in creating a power of attorney. And it's important to think carefully about who you appoint and that you trust that person's honesty and judgment. If you have no family members or friends that you can or want to appoint, you can appoint a respected professional, such as your lawyer, accountant, or a trust company. You cannot appoint anyone who is paid to provide you with personal care or health care, or who works at a facility through which you receive personal or health care, unless that person is also your child, parent, or spouse. It's generally a good idea to appoint more than one attorney in case your first choice is unable or unwilling to act. There are specific rules for powers of attorney dealing with real estate. A power of attorney dealing with real estate is only valid for 3 years from the date of signing unless otherwise specified, or unless it is an enduring power of attorney and has been filed in the land title registry. I'll give you an example of the practical benefit of having a power of attorney. At the start of this year, I had some clients that purchased a pre-sale condo. With pre-sale condos, completion dates vary and are often moved. Instead of canceling their vacation, they drafted a power of attorney before they left. They were in Italy in the spring when COVID hit and they got stuck there. The completion date coincided with the time that they were away, but because of their POA, their daughter was able to sign the real estate conveyancing documents and use the power of attorney to continue to pay bills and maintain their lives until they were able to return. Moving on to representation agreements. These are health agreements that are sometimes referred to as a living will or a personal directive. The Representation Agreement Act allows you to appoint someone as your legal representative to handle your personal care and healthcare decisions if you're unable to make them on your own. A representation agreement creates a contract between you and your representative. There are 2 types of representation agreements, which are both dealt with in the Act. Section 7 of the Act deals with limited agreements, which cover straightforward everyday decisions, including personal care, limited health decisions, routine financial management, such as payment of bills, receipt and deposit of pension and other income, purchase of food, and making investments, as well as obtaining legal services. The benefit of a Section 7 agreement is that there is a lower test for capacity required to make one, so it can be helpful in a pinch if someone has already lost some capacity and is unable to make an enduring power of attorney or a Section 9 representation agreement. The downside is that this section significantly limits the types of things that a representative can do on your behalf with respect to healthcare and finances. Section 9 of the Act deals with general agreements, which involve more complex personal care and healthcare matters. A general agreement is needed for your representative to make decisions such as refusing life support if you become terminally ill, or the decision to move you to a care facility if that becomes necessary. We often have clients that ask us to include a clause about passing with dignity rather than being kept alive by artificial means. If that is your wish, there must be a specific clause in the representation agreement to that effect. Like with the power of attorney, you can appoint any person who is paid, you cannot appoint any person who is paid to provide you with personal or health care, or who is an employee of a facility through which you receive personal or health care, unless that person is your child, parent, or spouse. It is also good to name a representative that knows you well, that you trust, and ideally that lives in the same geographic area as you, as well as an alternate. Before a person agrees to act as a representative, that person should review and be aware of the duties and obligations that they will have as a representative. For example, your representative must consult with you as much as is reasonable to determine your wishes. Some of the other duties of representatives include the duty to take into account your current wishes, and if you're unable to express your wishes at that time, to take into account any wishes or instructions you may have given while you were capable of doing so. To act with the authority granted within the representation agreement, to keep your assets separate from their own, and to keep proper records, including creating and maintaining a list of your property and liabilities. Like with powers of attorney, it is important to name an alternate. Monitors are also an interesting aspect of representation agreements, because if you wish, you can appoint a monitor in your representation agreement, and they will be required to oversee the activities of your representative and ensure that they comply with the terms of your representation agreement. A monitor is required if the representative is authorized to make decisions concerning routine management of financial affairs, but not if the representative is the adult spouse, the public guardian and trustee, a trust company, or a credit union. In summary, it's good to plan ahead. Some of the primary benefits of estate planning and keeping an up-to-date will are to minimize probate fees on death, simplify your affairs to reduce the burden on surviving family members, and plan for the distribution of assets in accordance with your wishes. Powers of attorney and representation agreements are another piece of the estate planning puzzle. They can be a practical tool used while you still have capacity in certain circumstances, and if you lose capacity, can help ensure that you're looked after and your affairs are properly managed. Because there are certain formal requirements, for example, with respect to witnessing, to make valid wills, powers of attorney, and representation agreements, it is always best to seek assistance from a legal professional so that you can be sure that these agreements are valid and effective and avoid a future headache or additional legal costs. And that concludes our presentation, and I'll turn it over to Graham and Neil.
Just before you start, Graham and Neil, I just wanted to say thanks so much to Maria and Bobby. Very comprehensive presentation, jam-packed with a lot of information. We will be sharing the recording of this webinar with everybody after the event, and feel free then to follow up with their respective contact details on the screen. So with that said, for a financial planning perspective, over to Graham and Neil.
Thanks, Daryl, and thanks, Maria and Bobby, for a great overview of estate planning and what you need to think about and a number of things you should consider when doing so. Graham and I wanted to give an overview next of the kinds of charitable gifts that are available to you as a donor. We're sure if you're involved with this call, you already appreciate the great things that United Way can do for our community and are probably already considering one or more of these kinds of things. A number of these dovetail well with your estate plan and things you can consider along the way with your financial planner and your overall financial plan. I'll start off with just an overview of the different kinds of charitable gifts here. The cash gift is probably one that you're most familiar with. You're just able to make a donation to the charity of your choice. Another common one is a gift by will. This is doing your properly drafted will. You can leave a specific dollar amount or a percentage of your estate to the charity of your choice. You're also able to designate a charity as a beneficiary of your registered investment accounts, such as RSPs, RIFs, and tax-free savings accounts. A number of our clients do that. It is important to consider this in your overall financial plan, however, and review on a regular basis, as some of those accounts, namely a RIF account, is designated to provide an income to you throughout your lifetime, so it will generally shrink in value, where an example of a tax-free savings account is an accumulation account that you're regularly contributing to, so that will increase in value throughout your lifetime. So periodically you want to review and make sure that your designated beneficiaries are the appropriate size for what you had in mind for your financial plan. In-kind donations of stocks and publicly listed securities are another great way to support a charity and get a tax benefit for you as the donor. CRA allows you to donate an appreciated security and not have to pay the taxable capital gains if it's donated to a registered charity. So it's a great way to benefit both you and a charity at the same time. There are gifts of certified Canadian cultural or ecological property that you can make. There's a number of details. You want to talk to an advisor about that. You can donate a life insurance policy, and Graham and I will go into some detail of the various benefits, the ins and outs of that on the next slides. Charitable gift annuities are popular because they also provide the donor, you, a lifetime income and provide a benefit to the charity. You can set up a charitable remainder trust in your will. Through planned giving, you can establish a private foundation, although these are usually for the higher net worth individuals and perhaps with a $5 million or more donation to a charity or charities. But what's become popular in a number of cases recently is donor advised funds, and we'll go into some details in the various iterations of donor advised funds and how those can be a benefit to you in the coming slides. So if I look at life insurance as a way to give to charity, the general benefit there is that it doesn't tie up a lot of your assets today, as the gift is deferred until your death to the charity. It leaves your assets free to produce income during your lifetime. So you're not encumbering your lifetime, but you still are leaving a benefit to a charity. It enables you to make a more substantial gift in the future while paying relatively modest premiums today. So perhaps a way to multiply your dollars and make a more impactful gift to the charity of your choice. There's different ways to structure this. You can have it so that you receive the majority of the tax benefit on your death and for your estate, or you can structure it to receive the tax benefits on an annual basis along the way to reduce your taxable income. Again, as I mentioned, usually using life insurance, the charity will receive a larger gift than they may otherwise have done so. And it's important, we think, to inform the charity and let them know what you're thinking so that they can have some ability to plan for a future gift that you intend to make to them. It makes it more meaningful and perhaps more impact to your local community if the charity is able to plan a little bit around what you're thinking. The first major way to gift life insurance is through personally owned life insurance. So this would be where you as the donor purchase a life insurance policy yourself or change the beneficiary of an existing life insurance policy to the charity. The charity becomes the beneficiary of that life insurance. And when you, the donor, dies, the death benefit is paid directly to that charity. The donation is considered to be made by your estate, and your estate gets the tax credit. That life insurance, that tax credit is a non-refundable tax credit that reduces tax payable in the year of your death. The maximum donation credit eligible is 100% of the net income, both in the year of your death and the immediately preceding year. So it's important to consider what that might look like and make sure you're able to make the maximum benefit of that tax credit. It's a one-time tax credit received at death. The first $200 of a donation gets a 20% tax credit. Everything above that gets anywhere in the range of 46 to 50% tax credit on donations over $200. And that's depending on the province you live in and your specific income level. There are no carry forward, but as I mentioned before, you can carry back 1 year to the year immediately preceding your death. So the advantages of personally owned life insurance is you still control the policy. You can, if circumstances change, access the cash value or change the beneficiary of that policy. It usually leads to a substantial donation at your death, and the tax credit can help offset the taxes of your estate. The disadvantages are you do require sufficient taxable income in the year of your death and immediately preceding to take advantage of that tax credit. And another drawback might be that your surviving spouse can't use any unused tax credit. So it's important to have a look at what your long-term financial plan might look at and review it regularly.
So rather than you continuing to own the life insurance policy, you can also purchase or give an existing policy to a charity, and they become both the owner and the beneficiary of the policy. The donor, you, pays future premiums and gets a non-refundable tax credit every year that the premiums are paid. Now, if you require a larger tax credit, of course, you can supplement the premiums with other charitable giving to meet your tax goals. With charity-owned insurance, the tax rules during a lifetime, again, a non-refundable tax credit, which reduces your tax payable each year that the premiums are paid. Again, the first 20% of the first $200 and 46 to 50% on any amount over that. The maximum donation eligible for the tax credit every year is 75% of the net income of the previous year. And you can carry unused or excess donations forward for 5 years, giving a great deal of flexibility. The advantages of charity-owned insurance, you make a donation credit every year by paying the premium. The charity has access to the cash value if it's a whole life or universal life policy, and the charity as owner can't be changed. The disadvantage, the charity as owner can't be changed, and there's no tax credit upon death that'll aid in the estate planning at the time of death. Now, donor advised funds, these aren't to be confused with the United Way program with the same name, which is more of a multi-year giving program. The donor advised funds we're discussing here are often used as an alternative to the expense and cumbersomeness, thank you, of a private foundation. You can donate cash, publicly listed securities, life insurance policies, and gifts from your estate for as little as $50,000 of an initial donation. The tax receipt is given at the time of donation and for any subsequent gifts throughout your lifetime. It's a great way to get fine control over the managing of taxable gains issues and general tax planning. Also, as it is an ongoing program, you benefit from the ongoing professional investment management and growth of the investments over time. This allows you to use specialized investment strategies that are important to you. If you have a preference for environmental or social or corporate governance, screen portfolios, you can continue to use them. And you can select and change the charities you'd like to support with ongoing grants throughout the life of the fund. So it's a very flexible, low-cost charitable giving account that gives you the managing charitable donations on behalf of the family, and often used as an alternative, like I said, to the private foundation, which can be practical only if you have a very large amount of money in the amount of $5 million to donate. The charitable giving account under a donor advised fund is housed within a larger public foundation. And the advantages over a private foundation is the administration is considerably less, reduced time and cost in the management, and you maintain the ability to control the assets and to receive recognition for gifts that come from it.
So overall, a donor advised fund can be a simplified way to give amounts throughout your lifetime to a charity with relatively low administration costs. It can personalize and preserve your legacy and your family's charitable giving interests through this kind of donation. You retain influence over the grants, so you're able to support a number of different charities, ideally including United Way, throughout your lifetime. And then after your death, you can pass that along to other family members, or specifically a trustee, or simply state the wishes in your will as to what you'd like to have happen to those funds after your passing. It does allow you, as Graham mentioned, to manage your ongoing taxation issues throughout your lifetime and build assets for future tax-free gifts to charities. You can benefit from professional investment management. The administration is taken care of. Legal and accounting costs are fairly low in these kinds of funds. And it does produce that legacy that you might be looking for, either publicly or privately within your family, to support the number of charities and the communities that are important to you. We've touched on a number of charitable giving options here, but I think we would both recommend that there's a lot of different ways to give to charities that are important to you. It's important to talk to your financial advisors, talk to your lawyers about your estate plan, and come up with a plan as to what you want to have your money do for you. There's probably ways in here that you can maximize both the benefit to you and your family and to the charities you want to support. It just takes a little time and expertise to suss out the best options so everyone wins.
Well, thank you very much, Graham and Neil. That was a fantastic presentation. And thank you to the audience. We've been fielding a few questions here. Please do keep them coming. I've got a couple of questions for Maria and Bobby. And I think it's just up to the two of you who would like to answer. One of the questions that's come through is that from someone in the audience, we have a will that was created in Washington State. Is it legal and recognized in BC? And also linked to that, we also have a durable power of attorney and a durable power of attorney for healthcare decisions and nomination of guardian created in the same Washington State's office. So perhaps you guys could speak a bit to to what the implications of that are.
Yeah, I'll take this one. So with respect to the will that was made in Washington, my understanding is that it can be probated in BC. You would just have to prove that it was validly made pursuant to the Washington's laws. We would, in those situations though, where you have assets in multiple jurisdictions, we would generally recommend just creating two separate wills dealing with the assets in the two locations. So you would have a will in Washington dealing with your American assets or your assets in Washington, and then a will in BC that's just dealing with your assets that are located in BC. And the question about the powers of attorney and the health agreement that was made in Washington, I actually don't know the answer to that off the top of my head, but I'd be happy if you shoot me an email. I believe my contact information was linked. I'd be happy to follow up with you and answer any questions about that if you're wondering about whether they'd be valid in BC.
Excellent. Thank you very much, Maria. The other question is again directed to the legal team. Just to review the idea of the monitor again, if you could, someone has just asked if we could just go through that one more time.
Sure. Yeah. So I'll take that one as well. A monitor is somebody that you can appoint in a representation agreement, and basically what they do is they oversee the activities of your representative just to make sure that they're complying with the terms of the representation agreement. Another way that you could do that is you could appoint two representatives that would have to agree on any decisions that they make about your personal or health care. That's another option if you just want a little bit of oversight.
Excellent. I've got one last question here for you, and that is, do you need a lawyer to prepare a codicil?
Well, great question. Well, like a will, a codicil must meet certain requirements for it to be valid. Otherwise, it can be a challenge or be struck down. So I would recommend a lawyer prepare a codicil. And also the same requirements we would fulfill the same requirements when it came to filing the codicil. We would still prepare a will's notice. Otherwise, if it can't be found, there's a presumption that the will maker revoked the codicil, and we would have to overcome that presumption. So I would recommend a lawyer prepare a codicil.
Thanks very much, Bobby. There's just one follow-up question, I think, for Maria, just from the from somebody in the audience. Just in terms of the monitor, did you say that the monitor couldn't be a spouse?
No, a monitor can be a spouse. There's just so if you have that Section 7 representation agreement that allows your representative to deal with certain financial decisions like paying your bills, you're actually required to have a monitor unless they're your spouse. So then it's up to you. But if your representative is allowed to make financial decisions on your behalf, the Act requires, generally speaking, that you have a monitor. If that's clearer, hopefully.
Fantastic. We still have a bit of time for questions, so do keep them coming. Filling a number of legal questions here. Assuming a person was okay with the WESA rules, what are the pros and cons of having a will versus dying intestate? What is your opinion on that, Bobby?
That's a great question. If that person just wants to send me an email, I'll be happy to answer it in more detail, just because that's quite specific. Circumstances might be different in the future, so I'll be happy to just kind of give my legal opinion and just thoughts about that. So if that person just wants to give me a call or shoot me an email, that would be great.
Okay, fantastic. I'll definitely pass that along. One last question: can or should the executor be a beneficiary? That's an interesting question, I think.
Yeah, an executor definitely can be a beneficiary. That's simple enough there.
Okay, excellent. Well, I think that is all we have. Let me just see if there's any more Q&As, questions that have come through. I think that is it. Thank you to Graham and Neil. Thank you so much for your presentation. Thank you, Maria and Bobby. It was fantastic. Over to you, Mark.
Well, thank you very much for attending today, and hope you found it beneficial, informative. Appreciate the questions, the opportunity to interact. I'm not sure the legal area is that much more complex. There's lots going on, and presented as well on the financial front. So we'll ensure that everyone has the contact information for our colleagues here on the panel, and I'm especially grateful for your time, Neil and Graham, Babby and Maria. Thank you very much. We really appreciate the support. And I want to wish everyone a great rest of the day, and stay safe out there. Thank you.
Thanks very much. And just a last note, we'll be sending out this recording in the coming days, and please feel free to be in touch if you have any questions or would like any more information. And please do look at that will planning guide and legacy giving brochure that we sent out, as they're quite useful, I think, in the context of the presentations today. So thank you very much.